Hi, everyone. My name is Damaris. So I'm a leader in social justice, democracy, and anti-corruption. And I'm also founder and the executive director, Youth for Integrity Building Organization. So most people keep asking me, Damaris, what's the difference between forms of corruption and corruption typologies, or better still, types of corruption? So let's think of corruption as an ecosystem. So forms of corruption are like the species. These are the specific manifestations or shapes it takes. And that is the actual act people commit. For instance, people can commit bribery, fraud, patronage, cronyism, rent seeking, money laundering, insider trading, favoritism. There's so many forms of corruptions. Yeah, so those are the forms of corruption which can be the species. And then we have the typologies, which are now the taxonomy. These are the classifications, or better still, the analytical categories we use to describe corruption in terms of scale, motivations, frequency, control, purpose, and origin. So in other words, typology is the nature, the scale, and the context of the act, and not the act itself. So the act itself is form. So the form, it is the crime itself. And typology is the crime's profile. Yeah. And in the Kenyan legal arena, the forms are normally defined and criminalized under the specific laws. Yes. And that's why forms are normally used in prosecution and public naming. So for instance, one can be able to actually say that this is bribery and is illegal in the Bribery Act 2016, section 5 to 9. Or someone else can say this is embezzlement and it is illegal in the Penal Code, section 280 to 283. Someone else can say, yeah, no, this is a fraud and is illegal in the Penal Code, sub 63, sections 313 to 322. Yeah, so basically, these are what prosecutors charge and in the court of law with clear penalties. Yeah, so this supports the rule of law. When it comes to typologies normally help in they just help in policy design and strategy formulations. Yeah, because they're not necessarily written as offenses in the law. They're just analytical tools for policy making investigators and researchers who wants to understand the patterns. So for instance, one can label a case as petty or grand. For instance, let's say an act of bribery. An act of bribery can either be petty, sporadic, systematic, and so if we are labeling a case and label it, let's say petty or sporadic or grand or autogenic, yeah, controlled and controlled, it can actually influence investigation priority. Yeah. So when it comes on the desk, it's labeled as petty and this one is labeled as grand. So they will be able to prioritize which investigations to be carried out immediately or faster before the other cases. So it actually influences investigative priority. And then when we also classify it as either extortive or transactive, so one can be able to guide in prevention strategy and targeted reforms. Yeah. So the bottom line is this. The bottom line is this. Forms are the legal offenses you can be prosecuted for. Yeah. Or you can prosecute someone for. And typologies, these are strategic classifications you use to design smarter anti-corruption responses. So it's very important for us to understand both. Yeah, because this will help us in fighting corruption with a lot of evidence, confidence, law, and precision, and not just outrage. Yeah, so I just hope that you guys have been able to understand the difference between forms of corruption and corruption typologies. Until next time, guys, bye-bye.